Stuart Nash.
Thank you very much, Mr. Speaker. As my previous colleagues have alluded to, I think all parties are actually supporting this legislation through the House for a number of reasons, but the main one is it's common sense legislation. This is work, very good work undertaken by the Minister, which is simply a continuation of the work that Leanne Dalzell started and Simon Power continued. I am slightly concerned, Mr. Speaker, because as Simon Power mentioned a couple of weeks ago, sir, Simon Power has actually been the hardest working National Cabinet Minister. In fact, he's responsible for over 40% of the bills before the House. And the Honourable Simon Power has decided to leave. I'm not too sure why. You can only speculate. I suspect the reason he's decided to leave, Mr. Speaker, is because he is the only one doing any work on that side of the House. He is the only one with a little bit of a plan. Mind you, Simon Power's plan was to sell state assets. But when you take away the man who brings 40% of the legislation, you're left with a bit of a vacuum in the National Party, and you're certainly not left with any sort of plan to drive economic growth. In fact, it was quite interesting to hear Katrina Shanks stand up and say that this is part of an economic plan. Well, Mr. Speaker, I'm sorry, but this is not part of an economic plan. This is good common sense legislation that we work together on to help New Zealanders regain their trust in the financial markets. But this is not a plan for economic growth. The other reason, of course, we heard is that Mr. Joyce and Mr. Power had an argument, and Mr. Joyce came out top. It was about the leadership, and I understand Mr. Key is going to leave soon, but I do see Mr. Joyce sitting in the front row. It's only one more step to the leader's chair, and you're there. So as Simon Power leaves, so Mr. Joyce comes in. But anyway, Mr. Speaker, I digress. We're debating two bills together. We're talking about the Financial Markets Regulators and KiwiSaver Bill. We're also talking about the Securities, Trustees and Statutory Supervisors Bill. Initially, these were considered as single bills, but they were brought in together. I think we all agree because the objective of these bills is quite similar. But I just want to talk very briefly about each bill. The Financial Markets Regulators and KiwiSaver Bill, what it does is it establishes a Financial Markets Authority, or the FMA, and sets out wider enforcement and surveillance powers that are currently available to regulators. It boosts their power, basically. It also makes changes to the regulation of registered exchanges and improves the regulation of KiwiSaver schemes. And this is good for all New Zealanders, because I think there's well over 1 million New Zealanders who are enrolled in KiwiSaver, and it's up to us to ensure that they are well protected. Now, KiwiSaver, of course, was an exceptionally good Labor-led government scheme that was put in place, and it was taken up by the vast majority of New Zealanders. Financial market reform, well, as I mentioned, Labor started the financial market reform process, and we are pleased that, in fact, the government has decided to continue with our good work, with Labor's good work. As mentioned, Leanne Dalzell actually set up the Capital Markets Development Task Force in 2008, and she did this so she could develop a blueprint and an action plan to develop New Zealand's financial system. She saw what was going on, she knew something had to happen, and so this is what she did. And as mentioned, we're very pleased that Simon Power has decided to act on the recommendations of the task force report, one of which was a single market regulator. The Labor-led government, it did take a number of measures aimed at strengthening our financial markets, and this process was accelerated, of course, by the global financial crisis and a spate of finance company collapses. Mr. Speaker, if I may, I wouldn't mind just outlining some measures that the Labor-led government took that led on to this bill, or that was the genesis of this bill. And let me give you a couple of examples. For example, regulations giving trustee companies robust powers to supervise finance companies on behalf of investors. Now, that doesn't really need much explanation because, as we know, there are about 40 finance companies that collapsed. It took about $4 billion out of the pockets of ordinary, good, hard-working New Zealanders and set a hell of a lot of them backwards. In fact, I've talked about this 4 or 5 times in the House already, Mr. Speaker, and as I mentioned, there have been numerous cases where people, this cut to the core to the extent that people actually committed suicide. This was an insidious process where men and women who were in charge of monitoring the governance of finance companies didn't do their role, and the result was catastrophic. The other measures, we allowed criminal prosecutions against finance companies that had misled investors to be funded. This is to be funded from Security Commission's litigation fund. And I think we're beginning to see this at the moment, Mr. Speaker. These directors are in front of the courts now. Some of them have been tried and some of them have gone down. We can't comment on that, but yeah, I don't think anything can make up or can replace the losses suffered by Kiwis that had worked incredibly hard for this. But what this is doing is just putting processes in place to ensure that New Zealanders can have a degree of confidence in the financial markets. We regulated financial advisors and financial service providers. Another one that's important, before this legislation, anyone could call themselves a financial advisor. You could have done anything and still tout yourself as a financial advisor, and if a consumer didn't know any better at all, then they were open to abuse. And as we know, many did and were rorted. It was incredibly sad. Reviews of financial products and providers and financial intermediaries were commenced in 2004 and 2005, and this was to improve the regulation of non-bank financial institutions, financial products and financial advisors. We amended the Securities Act to strengthen rules around insider trading and market manipulation, and we passed securities markets legislation which introduced a co-regulatory framework for supervising registered exchanges. I think some of this stuff can get quite complicated, of that there is no doubt, and I won't try and get too complicated, but I think it is important that New Zealanders know that all members of this House understand that work needed to be done. And I think people also need to know that when this happened, we wish that it hadn't happened, of course. We all wish that the regulations had been in place, but they weren't. But what we now need to do is to say to New Zealanders that you can have confidence in the financial markets, because what we have done is introduce legislation that we are really working hard to rebuild that trust. Now, Mr. Speaker, I'm going to speak very briefly about the Securities, Trustees, Statutory Supervisors Bill. And the main aim of this bill is, again, to protect the interests of investors and enhance confidence in financial markets by requiring persons who wish to be appointed as trustees, statutory supervisors and unit trustees to be capable of effectively performing the functions of trustees, statutory supervisors and unit trustees. Also by requiring trustees and statutory supervisors and unit trustees to perform their functions effectively, and also enable trustees, stat supervisors and unit trustees to be held accountable for any failure to perform their functions effectively. As you can see, there's a lot of crossover between these two bills, and it's why the Minister suggested they be read together, and it's why the Labour Party agreed with this. But what it is it is important, because people do need to know, Mr. Speaker, that we will ensure that people who act outside the law or in an unscrupulous manner will be held to account. And I think there's great concern still, sir, great concern around the country that many who perpetrated the ills that resulted in finance company collapses have not been held to account, and I hope they will be. This bill also provides the Securities Commission to be notified by trustees or statutory supervisor when any issuer they supervise gets into difficulties, and gives the Securities Commission enhanced power to intervene in these circumstances. So this isn't the ambulance on the bottom of the cliff, but hopefully what this is a safeguard, so when someone does get into trouble, they hold up their hands and say, wow, there is an issue here, we bring in the experts and they can save it. And again, just another step to ensure that good, hard-working New Zealanders who have saved for their retirement do not get rorted. This is all very important. The role of trustees and statutory supervisors is very important, sir, in ensuring the interests of investors are properly protected from the unscrupulous, the incompetent and the inept. And the trustees' role is basically, sir, to monitor the issuers of certain types of securities to ensure that the issuer is complying with the terms of its offer to investors as stated in the issue document or prospectus. But, Mr. Speaker, I'd just like to make a couple of points. Whilst this is very good legislation, as mentioned, it has its genesis in Labour Party policy and Labour Party actions, but, sir, it's not a plan for economic growth. There's no plan for economic growth there, and that is what the people of New Zealand really want to see. They want to know when the government is going to present something they can grab hold of and say, a vision for the future. No vision. Mr Speaker, I commence this bill to the House. Thank you very much.